Morning, everyone. Thank you for joining us this morning. Apologies for the delay in getting started. I don't think it'd be a webinar if we didn't run into a couple of technical issues. If you've any issues in hearing me, just let me know. We've got a Q&A tab, or there should be a Q&A tab at the top there. Any questions that you ask will drop into the side. We'll deal with questions at the end. There'll also be a recording of the meeting that's going to be sent out afterwards. If there's any specific questions that we're unable to deal with during the webinar, we'll get in touch with you separately to deal with any specific points. So what I'm going to be discussing this morning is the steps that you need to take at the point at which you've been notified that an employee is pregnant. Apologies if I'm going over ground here which you're all familiar with, but for the avoidance of doubt, I wanted to run through the steps which we should generally be taking once you've been informed of that pregnancy. Stephen is then going to be talking you through the steps you need to be taking during that maternity leave period. I'll also be covering a couple of the potential claims which can arise in certain situations and the best way to mitigate against those claims as well. So, obligations on you once you receive that notification of the pregnancy. The notification can be given verbally or in writing. If you request confirmation in writing, that's something that the employee has to provide, but otherwise it's entirely a choice for you if you accept the notification verbally or in writing. That must be provided to you no later than 15 weeks before the due date, and the employee must confirm the fact that they're pregnant, the expected week of birth, that's usually recorded in a MAP B1 form, and the date that they wish to start maternity leave. And of course, the earliest that they can start is 11 weeks before their due date. The next step we would advise you then take is looking at risk assessments. The Health and Safety Executive has produced a very helpful guide to assist employers with the types of things that you may wish to include as part of that risk assessment. Regulation 16 of the Health and Safety Regulations provides that where the workforce includes women of childbearing age, there's a specific risk assessment that's required of any risk that arises from the condition of being pregnant in relation to her work. The employer's duty is then to take steps to avoid the risk to individual employees, or if they cannot take those steps, the next step is then to consider altering the terms and conditions of her employment. The duty to avoid the risk or alter the terms and conditions only applies when you're notified of the pregnancy. So the point at which you receive that notification, that's where your obligations as an employer kicks in. That duty on you to carry out that risk assessment and monitor the situation, that continues only during the pregnancy and up to 6 months after the employee has given birth, or if the mother is breastfeeding, up to the end of the breastfeeding period. So that's the period of time that your duty to assess risk continues for. If the conditions cannot be altered, so if the work conditions for that particular employee cannot be altered, the employee must be offered suitable alternative work. Of course, that's going to depend on the type of work they're undertaking as to whether or not that's feasible. If that's not possible, if there isn't any suitable alternative employment, the employer must then suspend the employee on pay. A failure to carry out those risk assessments can give rise to a claim for pregnancy discrimination. However, there does have to be risk there. There needs to be some risk that they're placed at. The duty to do the risk assessment, of course, is only triggered if certain conditions are met. Notification of the pregnancy. So as I said earlier, your duty as employers only kicks in once you've received that notification. The second step, the work could involve risk. Again, that will be assessed on a case-by-case basis. And finally, the risk must arise from the working conditions or the processes carried out by the employer. So once those three conditions are met, that's where the duty to carry out the risk assessment is engaged. Ensure, of course, that those risk assessments are in writing and consult with the employee about that risk assessment. The third step, so you've received notification of the pregnancy, you've taken steps to carry out a risk assessment. The next step is then responding to the employee. So we must respond within 28 days of receiving the information from the employee that she's pregnant and the date on which she intends to take maternity leave. Stephen will go into a bit more detail about this with you, but generally they're entitled to 52 weeks maternity leave. And this is something, of course, that you need to confirm in writing to them, and then return to work date. If they want to change this, they must give you 8 weeks notice. It might be easier just to work on the assumption that they're going to take the full year, and if the employee notifies you of any change, that's fine. And as I say, they must give you 8 weeks notice of any change to that return to work date. A failure by the employer to provide that information means that you cannot prevent them returning early without notice, and you may not be able to discipline or dismiss them for delaying their return from maternity leave. So it's really important that we've set that information out in writing. Practically, finding yourself in a position where an individual, it's at the choice of the individual when they're coming back, and there's no obligation on them to notify you. That, of course, can put you in a tricky situation, and it's difficult for you then to plan around staffing needs. You may want to also consider including the following information when we're responding to the employee in writing. The fact that they will have rights to paid time off to attend antenatal classes. Usually that is evidenced by appointment cards, except for the first appointment. It's not necessary for the employee to produce evidence. If you do request that evidence, the employee has to provide it. You may want to consider setting out their entitlements. That's ideal for the employee, but also for you as employers. It just works as a gentle reminder as to what those entitlements are. That can include maternity pay, certain benefits, etc. If they don't qualify for statutory maternity pay, what we would generally do then is provide a form SMP1, which will help that employee apply for maternity allowance. You may also want to set out, which can be a bit of a contentious issue, how and when holidays will be taken. So if that's something that you've already agreed with the employee, set that out in writing with them so everyone's clear as to what the arrangements are, whether or not holidays are being taken beforehand or holidays are being taken afterwards. So some potential risks and how to mitigate against these risks, and this is generally the point at which we become involved, assisting companies with defending these sorts of claims. The Equality Act, that sets out predominantly all the rights that are afforded to a pregnant employee. This, in terms of pregnancy itself, pregnancy discrimination can only take place during what's called the protected period. That begins when the pregnancy begins and ends either at the end of her additional maternity leave period or when she returns to work after her pregnancy, if she has the right to ordinary and additional maternity leave, or at the end of the period of 2 weeks beginning with the end of the pregnancy, if she does not have the right to ordinary and additional maternity leave. So during that period, the protected period, that is when, if an individual is to pursue a claim for pregnancy discrimination, it will be for alleged discriminatory acts that have taken place during that protected period. Outside of that protected period, an employment tribunal will not have jurisdiction to hear a claim for pregnancy discrimination. Such circumstances, the employee may present that as a claim for sex discrimination. Unfavourable treatment, as far as Section 18 is concerned, this must be unfavourable treatment in relation to a pregnancy of hers. It may seem obvious, but claims for discrimination can manifest themselves in a number of ways, and in certain situations, the individual who's complaining of the discrimination doesn't necessarily have to be in possession of that protected characteristic. However, the position with pregnancy discrimination is that only an individual can bring a claim against a pregnancy of their own. That may be because of the pregnancy itself. It may be due to illness that the individual has suffered as a result of her pregnancy. If an individual is taking sick leave, it's important to have a look at what the reason for the sickness absence is on the fit notes. Treating someone less favourably because of the fact that they're on sickness absence because of a pregnancy can give rise under Section 18 to a claim for pregnancy discrimination. It'll also be discriminatory if she's treated unfavourably because of the fact that she's on compulsory maternity leave, or she is exercising or seeking to exercise her right to ordinary or additional maternity leave. You may have heard of the phrase victimisation. It depends in what context that you hear. It can have a number of different meanings. In this particular context, it's given a very specific definition by the Equality Act. Victimisation occurs when an employee does a protected act. Certainly in our experience, members of staff who are pregnant looking to take maternity leave, sometimes raising concerns about risk assessments or the lack of a risk assessment. Those things may be classed as a protected act. So that is where an individual is raising concerns that their employer is not complying with their obligations under the Equality Act. So, for example, a failure to carry out a risk assessment, that may qualify as a protected act. In order to complete the claim for victimisation, what the employee must then go on to show is that they've been put to a detriment as a result of raising that protected act. I've just set out on the slide there what a protected act is: bringing a claim under the Equality Act, giving evidence or information in connection with proceedings under the Equality Act. The third one you can see is extremely widely drafted. That says doing any other thing for the purposes of or in connection with the Equality Act. And finally, making an allegation that someone has breached the Equality Act. To mitigate against risk, where individuals have raised concerns about either risk assessments or some other way in which an employer has handled the pregnancy, it's important to consult with the employee, document those concerns and reach a resolution. There's far more risk involved where those concerns are raised, there isn't an investigation, there isn't an outcome delivered, and subsequently an employee either is dismissed or isn't brought back into the position they were previously. That allows an employee to then speculate as to whether or not the reason for that was because they were raising concerns about the way in which the employer had handled the pregnancy. An employee also has rights under the Employment Rights Act 1996. This is the right not to be subject to any detriment by the employer for a prescribed reason. A prescribed reason is one which is prescribed by the regulations as relating to pregnancy, childbirth or maternity, including maternity leave. Those rights are always also set out at Regulation 19 of the Maternity and Parental Leave Regulations. So the takeaway there in terms of mitigating risk, as I say, always important to consult with members of staff whenever they raise concerns. The risk assessment is a huge part of this. As I say, the Health and Safety Executive has some really good guidance online, and the more that you're consulting with that employee before she takes maternity leave, and the more that you're able to get those things in writing and agreement, both you and the employee have a better understanding as to what the arrangements are on their return. It significantly reduces the risk of a claim. In our experience, these risks tend to arise where individuals have raised concerns, they've not really been addressed. That individual is then on maternity leave for up to 12 months, and on return, the environment is quite hostile because they've not had these arrangements in place, and the individual feels as though they've just been left for 12 months. So that's the point at which you're notified of the pregnancy. I'll hand over to Stephen. He's going to deal with the steps you need to take at the point at which you've been notified of the pregnancy and then they're taking maternity leave.
Okay, good morning everyone. My name's Stephen Woodhouse. I'm a senior associate here at Stevenson's, and I'm just going to work through the maternity side of things, following on from Adam's focus on the pregnancy issues. I've tried to focus more on the do's than the don'ts, so you can take away from this presentation practical steps rather than a huge list of things that you shouldn't be doing. We're starting off by looking at the fundamentals regarding maternity leave. And the first one is that the employee is entitled to 52 weeks maternity leave, which is made up of ordinary and additional maternity leave as well. Now, unlike maternity pay, which we'll come onto under point 2, it's something which arises on day 1. So they have the right to take that maternity leave from day 1. And if we contrast that with the second issue there, which is maternity pay, that arises after they've had 26 weeks service at the 15th week before the expected week of childbirth. So it's a bit of a mouthful. And in addition to that, they've also got to earn at least £123 per week on average. Now, if they do qualify, statutory maternity pay is payable for up to 39 weeks, and they're entitled to 90% of their average weekly earnings before tax for the first 6 weeks, and then £156.66 or 90% of their average weekly earnings, whichever's the lower, for the remaining 33 weeks. After the 39 weeks, though, if they decide to take 52 weeks maternity leave, that last portion will be unpaid unless they choose to take holidays, which we'll come on to in a moment. And statutory maternity pay is paid in the same way as normal wages. For example, it's on a monthly or a weekly basis, and tax and national insurance will be deducted as well. And the third fundamental right relates to shared parental leave, which is a much more recent invention. And here the employees have got the right to give up part of their maternity leave period and statutory maternity pay in order to benefit from shared parental leave and shared parental pay, which allows them to, as the name suggests, share it with their partner. They can share up to 50 weeks. The only aspect that's not covered by it is the first 2 weeks, which must be taken by the mother following the birth. But after that, there's an ability to share 50 weeks amongst the parents. And the partner must also meet the continuity of employment test that we talked about under the number 2, which was the maternity pay, which is that they've got to be employed for 26 weeks by the end of the 15th week in order to be eligible. The fourth point there, and this is an issue that often crops up and is forgotten about during maternity leave, is that the employee continues to accrue their holidays during maternity leave. So it's an important distinction there. And then the final point relates to enhanced legal protection in respect of, as Adam touched upon, not being treated less favourably because of your pregnancy or maternity and the different aspects that Adam touched upon earlier. But there's also a special category there relating to redundancies and Regulation 10. Regulation 10 is referring to Regulation 10 of the maternity and paternity regulations, and that gives employees who are on maternity an absolute right. And that is that if in a redundancy situation, a suitable alternative vacancy arises, they must be offered that position at the expense of any other employee without requiring them to go through a competitive interview process. So it's an automatic right rather than something which they have to fight for. And we'll now just move on to consider the 3 aspects of maternity leave. So just before we go on maternity leave, what practical steps do we need to take during maternity leave and then planning for the return? So starting with before the maternity leave, administration and paperwork. Get the paperwork in order. That's something that, again, I've seen time and time again in practice, people don't do, and it's all a rush job at the last minute. So make sure that everybody's got the right paperwork, the MAP B1 form, that the notification process that Adam talked about in terms of notifying you of the pregnancy, and all the records are up to date in that respect, and when they plan to start and end their maternity leave, and also the arrangements around maternity pay. The next point there is handover of work. So first of all, you need to discuss before they go off, not on the last day, the workload and the handover process. So are you going to recruit somebody to cover their role for the period of maternity leave, for example? And do you need to bring that new employee in earlier, say 2 weeks earlier, to allow that handover and that familiarisation with the role? Because if you bring them in after the event, you've lost that opportunity to pass over key information. And if you're not going to hire somebody specifically to cover maternity, and it's going to be redistributed amongst other staff, how's that going to work? You know, will it be split evenly? Is there somebody who's going to take a lead role in terms of covering that employee on maternity leave? So think and plan ahead is the key message with that. And I think it often gets lost with everything else that's going on. Holidays prior to maternity leave, again, have they got any annual leave left? And again, this is something to look at 2-3 months out. We're obviously aware, as we've touched upon, that the employee will accrue a significant amount of annual leave that they're not entitled to take during the maternity leave period. So it's always sensible for you and for them to use up the holidays where possible in advance of the maternity leave, so that they're starting with a relatively clean slate before they build up a significant amount that they'll then need to take. It's all subject to the situation at the time. You might be requiring them to finish on certain projects and it's not feasible, but just have that thought in your mind 2-3 months out before the maternity leave starts, and it will help you in the long run. The next one we're looking at is obviously the employment status. So defining your contracts of employment, what's going to happen, what the rights going to be during the maternity leave. So we've mentioned there bonuses, benefits. Are they going to continue to be entitled to receive bonuses? Is that a policy that you have? Is that something that you're looking to implement? Whatever the decision, it's important to have clarity from all sides so that there's no confusion and you're not facing grievances and things like that arising from a failure to pay a bonus during maternity leave. And again, practical arrangements around pension. So for example, does the employee want to make additional contributions during the maternity leave period to top up the contributions that you as an employer are not making? So those are just practical steps that you need to think about before they go off on maternity leave. The next issue then is, what do you do during maternity leave, and making sure that you're dealing with the key issues as and when they arise. So how does the employee want to be spoken to or contacted? You know, agree that before they go off so that you can abide by their wishes during the maternity leave period. Do they want to receive regular updates, job vacancies, things like that? Or would they rather just be kept out of it? Whatever the situation, agree it in advance, and then there can be no problems during the maternity leave period. Consider, and it's a relatively early stage, obviously, in maternity, but keep in touch days. You know, when are they going to, it tends to be used towards the end of the maternity leave, to be honest, but perhaps plan ahead and say, well, is that something that you're going to want to utilise, and maybe even outline the dates or months perhaps that's going to be possible. So they might want to go on an away day or a particular conference that's important to them as part of their role. So I think ahead and make sure that if there is opportunities to undertake keeping in touch days and the employee wants to do it, that you give them access and opportunity to take that where reasonable. And again, update them on key changes in the workplace. So we've already talked about redundancy and things like that. But you know, they like to be involved often, but it goes back to that communication point from the start. If they say, look, I'm not interested in what's going on at work, I want to enjoy maternity leave, don't interrupt that, then that's fair enough. But if they do want to be kept up to speed on things, then make sure that you are abiding by that agreement. And again, we touched upon redundancy there, that if there is a redundancy process, they have enhanced rights, and it's important that they're not left out in the cold, again, as I've seen in practice, during a redundancy process, and in fact, they're entitled to preferential treatment. And again, it's relatively early on, but what are the arrangements going to be for returning to work? And already you can be thinking about things like flexible working. So it might be that you could invite them to partway through the maternity leave, invite them in for a meeting to have a discussion. It can be by telephone, Teams, whatever it would be, at their convenience, but have that conversation early, because if they are going to want to vary their hours after they return from maternity leave, you need to be able to deal with that process in advance. And again, you're not leaving things to the last minute. So if you've got a policy on that, make sure that they know where it is and they've got access to it, so they can see how the flexible working procedure acts in practice. And moving on just to the final stage, if you like, which is the end of the maternity leave period. What's going to happen with those holidays that are built up? Are they going to want to use them in a block? Are they going to want to stagger their return to work and perhaps return partially on effectively a part-time basis for the first few weeks? So if they work 5 days a week, they might take 2 days annual leave and work the remaining 3 for a period until those days of leave that they've built up have been used up. And think about the employee's position, you know, at the point that they're returning. So if they've taken 26 weeks or less, this period is known as the ordinary maternity leave period, then they've got the right to return to the same job after ordinary maternity leave. If they've taken more than 26 weeks, then you're then into the additional maternity leave period, and they've got the right to return to the same job. But if it's not possible because there have been significant organisational changes, then they can be offered a similar role, but it can't be on terms which are worse than before. So, for example, the following things should be the same: your pay, benefits, holiday entitlement, seniority. And those are the things that you really want to make sure that you're abiding by. And then in terms of the practical arrangements there, the handover and training, again, they've obviously had a time out of the business, and depending on the nature of the work that you undertake, things can, certainly in legal terms, things develop very quickly. Law changes all the time. So do they need to be offered training on certain aspects? Do they need to be on a course or something like that? Give them opportunity to get up to speed on any new developments in your area so that they're not coming back to work cold. And again, if you're working in a kind of professional services environment and you've got things like Ofsted or regulatory issues, they need to make sure that in order to do their role effectively, they've got that training under their belt. And handover, just practical steps again. Get that handover done, you know, whether it's the maternity leave cover, whether it's the previous, whether it's the existing staff who are taking up the work whilst they're on maternity leave. Make sure that there's that discussion in good time before the return, so there's no confusion on day one after they come back. Breastfeeding, it's a point which comes up time and time again, but speak to them. Is there any arrangements that they need on their return to work? Facilities for breastfeeding, expressing milk, things like that. You have an obligation as an employer to provide a space for mums who are breastfeeding to lie down and rest if they need to, but there is no specific legal right to offer specific breastfeeding breaks at work. So it's about making the environment safe and accommodating that for them. And family benefits, you know, things have changed perhaps drastically in their lives. So there might be things that you offer, such as a nursery or creche service, or childcare vouchers, or emergency nanny services, or something like that. Do you offer reduced childcare fees if you're a nursery or educational establishment? Think about the practical situation before the returning employee, and see if there's anything that you can do to offer them. Now, that's a whistle-stop tour in respect of the key issues around maternity leave, the different stages and the things that you should look out for. But I just thought it was important to offer you an overview on the key tenets of best practice during that period. So thanks for your time today. I think we'll be opening it up for questions now. If anybody wants to put any questions in the Q&A box, and I'll bring in Adam again so he can also participate in that.
We've got a question come in. Position if someone's role is split between a team while they're on maternity leave, but by the time they return, it means the role is no longer needed. As Stephen said, whilst that individual is on maternity leave, if a potential redundancy situation presents itself, it's important that they are still involved with that redundancy process. So the duty to consult with those members of staff and that pregnant employee, that doesn't change just because they're on maternity leave. So if we're considering whether or not that individual's role is needed, that individual will perhaps need to be pooled where necessary with other members of staff. So if a redundancy situation is to arise, it's important to consult with the individual on maternity leave together with those members of staff who are still in the office in the usual way. A failure to do that is where there is a risk, a significant risk will then arise that they may argue that it's because of the fact that they're on maternity leave, that's why they have been dismissed. So just make sure that you carry out that redundancy process in the usual way you would if they were in the workplace.
Yeah, and just to add to that, again, one of the strongest rights relating to maternity and pregnancy, and indeed one of the strongest rights throughout all of employment law is that right to be offered a suitable alternative vacancy to the person on maternity leave at the expense of other people. It's just a fundamental right that they have, which is unfettered. So it's important that you are recognising that and that you don't put them through, for example, an interview process or a selection process because they have the right to be selected effectively for that new position if indeed one is available.
There's another question coming, not too dissimilar. If the business changes and needs to move the person to a new role, can we offer training during the leave? As Stephen touched upon, there will be keeping in touch days as part of that maternity leave period. And it's a good point. If training's going to be offered, that would be a good opportunity as part of those keeping in touch days to discuss that with them. Again, just remember those changes cannot be made unilaterally. It'd be no different to the individual not being on maternity leave. There's a duty to consult in the same way as anyone else if there's a need to change a role. So an individual on maternity leave discovers that there's been a change to their role and they've not been consulted about that. Again, it's important we have a discussion with them, anyone else in the team who it affects, and the fact that the individual is on maternity leave shouldn't make any difference to that. We did a similar talk a couple of weeks ago, and a good question was raised insofar as miscarriage is concerned and stillbirth, and what are the rights of the employee in those circumstances, which was a good question. It's important you take specific advice because the rules change slightly depending on when the death occurs. If, generally speaking, if the baby is stillborn before the end of the 24th week of the pregnancy, it's treated as a miscarriage, and unfortunately that individual won't qualify for maternity leave or maternity pay if there's a miscarriage. However, if the employee needs time off sick as a result of the miscarriage, that should be treated as pregnancy-related illness. We touched on earlier the risk to an employer where they're found to have treated someone unfavourably because of the fact that they've been absent from work with pregnancy-related illness. Again, they don't have to disclose the fact that that there was a miscarriage. A failure to disclose that fact to you as employers means it will be very difficult for them to prove discrimination. However, where you are on notice of a miscarriage and that employee provides evidence of the fact that they're having to take sick leave because of that absence, again, just be careful. That's where claims for discrimination can creep in. It's also important to discount that absence for disciplinary purposes, for redundancy exercises. If you are factoring in that sickness absence that's related to pregnancy or in the circumstances of a miscarriage, again, that's where there's a risk of a claim of discrimination arising. The flip side to that is where the baby was delivered after the end of the 24th week of the pregnancy, the employee is entitled to maternity leave and maternity pay that they qualify for. So there's important distinctions there between the timing of the death, the potential claims that arise, and the importance, as I say, for you to make sure that you understood your obligations in that regard, so you can make sure that maternity pay, maternity leave is calculated in the correct way. Right, we've got another one in here regarding return to work. What's the position where there is a role change on returning following 12 months, where there was no prior consultation or communication? It's not on the basis of a role. Right, okay. It might be worth us speaking with you separately on that. It sounds as though you've got a specific issue there, and what we'd be happy to do is have a chat with you after the webinar. Leslie's going to be sending out a recording of today's webinar. Our details will be in there, our direct contact details. So don't hesitate to get in touch with us. It sounds as though you've got a bit of a live issue there that you could do with some help with. So by all means, if any of you have specific queries that you would like to have a discussion with us about, send them across.
Yeah, and just to add quickly on that, I think the one thing that jumps out to me from your question, it's relatively complex in its nature, but it talks about how there was no prior consultation or communication of a role disappearing, and they find out on day one of the return. Now, clearly that is very poor practice, because if significant changes are made to the business after 12 months, it can't be helped, but lack of communication and consultation is not particularly forgivable for an employer. They should be at least warning the employee and consulting with them properly, as Adam and I have said on numerous occasions through this. I think that's the key message. You don't leave the employee out in the cold whilst on maternity leave. Keep that communication line open and make sure that they are not feeling as though they've been left out in the cold.
Another point that you may come across, particularly on the return to work after maternity leave, is requests for flexible working, particularly where in respect of childcare needs. So individuals coming back previously on a full-time role, it's quite common, of course, that you will receive flexible working requests. And again, it's important the way in which you handle those requests. If they're not handled in the right way, that can give rise to, again, claims for discrimination, where the employee will, and indeed the courts have now reinforced this idea that statistically women have more childcare needs than men. That isn't something that needs to be proven. And so where they are placed at a particular disadvantage because of the requirement for them to work certain hours, those sorts of scenarios need to be handled quite carefully, just to reduce the risk of a claim arising. Got another question here. Do we need to do the risk assessment if the individual is working from home? We've done one for working from home. Do we need an additional assessment if they are pregnant? Just going back to what the three stages were. First of all, whether or not there is a risk. Generally speaking, best practice and for the avoidance of doubt would be to carry out that risk assessment, particularly if the individual has raised any concerns themselves. But consulting with them and ensuring, even if it is working from home, that they've got everything they need. Our advice is that would always be best practice. And once you've got that agreed in writing, again, it reduces the risk of a claim being brought at a later stage, or them alleging that concerns were raised but no one consulted with the employee. Safer not to make assumptions that working from home, what is the risk? discuss that with the employee, set out an assessment, ensure that both you and them have input, and it's signed off to that effect. But yeah, best practice would be to carry out an assessment in those circumstances for the avoidance of doubt.
Yeah, and just a final question here. I think there's a reference to the neonatal care leave and pay bill, which is currently going through. The obvious point on that is that until it becomes law, it obviously doesn't yet apply to you, and we'll be posting any updates in relation to any changes to the legislation. But there is already existing legislation which covers that kind of situation, because parents have the right to take time off in emergency situations for dependents anyway. So there is some protection there, but that predominantly is to do with the coverage of time off. It's not at present to do with pay, so perhaps that's something which can be welcomed in particular emergency situations. But again, with new legislation, wait to see what comes in, make sure that your policies are as up to date as they can be, and then it'll put you in the best possible position to be ready to respond to any changes.
Just other questions come in. If an employee asks to book leave for pregnancy termination, do we still need to follow the steps for pregnancy, i.e. risk assessments? Up until that point, yeah, the duty on you to carry out that assessment, time starts to tick as soon as you've been notified of the pregnancy. So you will follow those steps in the usual way, and then depending on when the termination takes place, again, just casting your mind back and bearing in mind the point at which the death takes place can have a direct impact on the right to maternity pay and maternity leave. But yeah, a good question. You would carry that assessment through up until that point of termination, the usual way, because those obligations kick in as soon as you're notified about the pregnancy. And of course, the legislation requires generally, although it's not something that we often get instructed at that point, but the regulations require generally that as soon as a woman is at a childbearing age, those sorts of assessments or risk assessments should be in place. But again, that will be case sensitive depending on the working environment. There has to be that risk in place before those assessments need to be carried out. If there are any other topics that you would find useful that you would like us to cover, as I say, when the recording is sent over to you, by all means, any suggestions. You may have found that you're having a common issue that keeps cropping up. We'd be happy to present on that. And as I say, if there are any specific issues you're having, by all means, our direct contact details will be in the email. Feel free to get in touch with us and we can see if we can help you further. But otherwise, we'd thank you all for joining us this morning. Apologies again for the delay in getting things live, but as I say, it wouldn't have been a Microsoft Teams presentation without that. So thanks for joining us, and as I say, please feel free to get in touch with us if you have any questions or specific issues you need advice on.